May it please my Lord, I'm Jude Yamkama. I appear jointly with Mr. Rogers Paul Kumbuka, Miss Patience Wemba, and Mr. Jurua Robert. My Lord,
I didn't get the name of the third council.
Patience Wemba. My Lord, Miss Christina Wori, the Chief Executive. My Lord, Miss Christina Wori, the Acting Chief Executive Officer of Uganda Law Society, is present. Together with Miss Mariam Nansukusa, also Manager Legal Aid, Uganda Law Society. My Lord, we are joined virtually by Mr. Moses Mwase, second applicant, who is also the chairperson of the election.
Who is who?
Who is the vice chairperson of the elections committee of Uganda Law Society. I look for the respondent, Ms. Patricia Namuyiga appears for the respondent.
My Lord, I'm holding brief for Council Robinson Momani. The respondent is not in court.
My Lord, when we ask, they are not in agreement with the Council of Uganda Law Society to proceed with the election before the question, the substantive question over whether the respondent to this application is qualified, is conclusively resolved. So we have a bit of an impasse. We thought maybe you should participate in these proceedings and see, we see what options there are, whether you can be convinced otherwise. But we had a meeting with the council, and that's the position he has instructed me to communicate to this court, and he is following these proceedings virtually.
My Lord, the position of the respondent is still maintained. She feels that the ruling of the High Court should be upheld, and the application before this Honorable Court is to do.
Now, first of all, want us to understand one thing, especially the council in this particular application. away from the other matters that we are handling. I am aware that complaints have already been raised as to the way this matter is being handled, and that I think there is insistence that we should go to the merit of the matter, especially when it concerns this particular application. The way I was handling these matters was supposed to assist the parties to come to this and that. It's only the law that can restrict me, and it is very clear. But I'll still leave it at that. Let us first handle the other application, then I will see what to do about this one. Please stay around.
So application number 99, 2025, Edina Gallery Society versus Ssemakadde and others.
May it please my lord. On manager legal aid. My lord, the second applicant, that's Mr. Edina, who is not present. For the respondents, my lord, Mr. Nicholas Aisu, appears for the first respondent. My lord, the second respondent,
represented by Alan Musasile, who is unable to make it today.
and Mr. Joshua Biamazima appears for the third respondent. My lord, the first and second respondents are not present. My lord, in terms of my lord, in terms of
I know them better than you.
from who represents Solicitor General on Council. Present. A lot of the team for Uganda Law Society. We also are joined by Mr. Oscar. My lord, the last time we were here, the team from the Attorney General's chambers had requested for time because they cannot dictate to the elections committee what it can do or not do in conduct of elections. And that is why I insisted on having the elections committee members present for this particular proceeding.
If I might ask, why weren't they attending the session?
My lord, we took it for granted.
Can you answer that for me? If you are not able to answer that, that?
Well, for every proceeding, of course, I give them a brief. However, it's never occurred to me that eventually they will have strong disagreements on how this matter evolved. Candidates when the will proceed.
Who is representing the elections committee?
I represent the elections committee because the elections committee technically, the chair Moses Ssemakadde was sued in this matter, and I gave him briefs, and that is why after that resolution was made, it had to be brought to his attention to give his views on whether they were ready to proceed and conduct the election, if that became the position from the court.
What was your advice to?
My advice to him was that maybe it is time to turn a blind eye at some of these legalities and try to move forward. And that remains my candid view. But again, I respect the view from the other side, who say that surely Uganda society.
Another society. All right, let's hear from Attorney General. What is your brief?
Please, Your Lordship, and for the record, my name is John Bosco Souza, Director of Legal Advisory Services in the Attorney General's Chambers, specifically for purposes of these proceedings, member of the Uganda Law Society Council, representing the Attorney General. My Lord, I'm with Ms. Stella Andrea, member of the Uganda Law Society Council, representing the Solicitor General. And we are with our colleague, Mr. George Kalemia, the Commissioner of Civil Litigation. My Lord, I would like to start by thanking you for encouraging us the last time we were here. Allowing us to start our business. I'm here to say two things, my Lord. One is that we associate ourselves with those who hold the view that we must follow the law. Whatever arises out of this proceeding must be in accordance with the law in terms of the conduct of the election. The independence that the committee needs to have. Regarding the outlines of the settlement that we looked at the last time we were here, we are happy to be part of the settlement, provided we are clear as regards the capacity in which we are in this matter. We here as Uganda speak off the street. We here as friends of God. In what capacity we are here as members of the Law Society Council as a matter of law, in fact. And therefore, our brief is that whatever decision is made here, it must be very clear from the wording, whichever order comes out, whether it's part of the consent, settlement, or a decision of the court, that the council is fully constituted and that we are here as members of the council. That's what we would like to communicate to the court.
Thank you. Attorney General is asking himself so many questions. For me, as far as I know the law, the Attorney General is a member of the council. And that law has not changed. Does it change, Mr. Wemba?
The law has not changed. So I don't know what it's about.
Much obliged, my Lord. That's very important and clear. But all we're saying is that must be documented. If the document has to come from the side of the people involved in these proceedings on behalf of the council. It's about the wording of any possible settlement. Much obliged, my Lord.
That document that assisted in that kind of wording, because I think, like you, I know the law. What's our way? The law is very clear on who must be on the law council, on the ULS council, and I think it includes the attorney general. That is the law I know, and I don't think that it has changed. If we are going forward with the settlement, I think that is not a matter that we should be looking at with any kind of worry. But what is important is are we going ahead with the settlement? Number one, the chairman of the elections committee is saying we cannot force him to do something that he wouldn't wish to do. But I think we can only ask him to do what is under the law. How does the elections committee call for an election? That is what is important. What is there in their regulations? What is there in their regulations?
For SI number 10 of 2016, that's the Uganda Law Society elections regulation. Specifically, regulation 13. It says where any law requires a representation of the society on a statutory or other body, the elections committee shall notify the members of the society of the day and place for the election of the society representatives.
Now, can't the elections committee do that?
They are listening in. They can do this, but for them, the elephant in the room are the orders in miscellaneous in Judicial Review 15 of 2024, Kevin versus Uganda Law Society and Moses Mwase. My lord, there are 3 orders in that Judicial Review. And if I may be permitted to read them, the orders are 1. An order of certiorari is issued quashing the decision of the respondents to exclude the applicant from the list of duly nominated candidates for the election position of the respondents' representatives to the Judicial Service Commission. 2. An order of prohibition forbidding the officials of the first respondent from publishing and circulating defamatory, derogatory, and misleading statements against applicants and interfering with the election process. 3. An order of declaration that the respondents were functioned as official after nominating the applicant and did not have legal basis to omit the applicant's name from the final nomination list.
Why don't we have fresh nominations?
My lord, fresh nominations would be in contempt of order number 1, which says the decision to exclude the applicant from the list of duly nominated candidates was quashed. Meaning there is a list, and on that list one candidate is not there. Then that candidate goes to court and gets an order saying, no, the decision to exclude her is illegal. Please add her to the list. So can you go back and begin a new process and exclude her? That would be that is the dilemma which the committee has, because for them, obviously, among the reasons why this court is that. Yes, my lord.
If you went back for a fresh nomination, then the law help you.
My lord, the law would help us, but we have a court order here which has to be respected. We already have other contempt applications in the law court. We want to add more.
What does the law say?
the law in terms of
If you are going for fresh nominations, then the law going to
minority would, except that it doesn't, in my view, the orders of the High Court cannot be circumvented by calling for fresh nominations.
we are in an appellate court.
If we got such an order alone from the court, of course we will go and work with it.
That is why I wanted you to consent on this matter. So that we all get out blameless.
I mean, that is true, and we are anxious to try to get a solution that works fairly for everyone. Unfortunately, the candidate herself is not here. And it's also holding brief. So I don't know whether I'm learning that there was a complaint made. I don't even have a copy of it, so I don't know what's going on.
I don't have a copy of it.
The road is just coming from the courts, maybe the complaint. But the bottom line is, it's a matter that it's a simple question in my view, and that even if we just this court won't decide to resolve it, the content of the elections committee are not unreasonable. And some of the orders that were made, the problem is order 1 and order 3. The order prohibits the officials from defaming how the
This is my dilemma here. It's one. That I'm not handling the substantive appeal. I can only talk at the provisions of the law within which I can work in an application to stay for execution. I've looked at both applications for stay of execution in these two matters. It is not easy to find where to start. But of course, whether difficult or not, a judicial officer is a judicial officer. I could come up with a decision then I look at this and decide. But I thought that we would go at length and have these matters resolved as a society. It's not like any other litigant. You are not like any other litigant. The things I write are going to be read and scrutinized by all of you. And we are jabbering over the law, but we all know it. Everyone there, you all know the law, don't you? Yes. So what seems to be the position now, as far as I can see it, is people just don't want compromise. And you must therefore be separated by code of law. And there, you can't vote unions. But elsewhere, it was raised that I have been held in this matter beyond what I was supposed to do. I was supposed to hear applications for stay of execution, give rulings and get out. I've indulged myself in a mediation, and therefore, according to some, I may not be impartial. It also been alleged that I have seen separate groups. Separate, I think that is wrong, we all know. But when you came to me, you came together. Yeah, and I've addressed you on this matter in a brief freestyle. But that's where we are now. But I know the underlying idea is that I think you should remain as confused as you are. I think there are some people who are interested in this kind of confusion that will remain as confused. Now, on that particular issue, if you cannot settle, then I must go ahead and do my work. It's the interim at this level. But in view of the complaints that have been raised, I have to refer. I have to confer with the head of the court and decide whether I can continue with this matter. If it is not for mediation, complaints have been raised there. So what I can tell you is that I am going to confer with the Chief Justice, the Deputy Chief Justice, and the head of this court, because the head of this court has also handled this matter, mediation. He reached somewhere, he also thought that he was going to have a breakthrough. It didn't happen. When I discussed with him that I reached somewhere, he was very happy with me. Now I'm going to report back that the land friends have agreed to disagree. And you see the way forward. If I'm advised to continue, I will continue and try to. Because I don't think that I can have you back here for anything else. Apart from either rulings or recusal. A settlement, yes, that is what we all wanted. And I thought that I knew you better than anyone else. But it seems I don't know the inner person in there. Every time we are at the end, when we have reached somewhere, when we come back, we're going back to the first step. So, I have a lot of resilience for this. Me, I wanted to see you get out of this quagmire, but it seems that it is not easy. Especially when it comes to the gentleman who are sitting in front of me. Today, Geoffrey just decided not to do that.
So it's here.
That's not an improvement.
I don't know Geoffrey when he's here in person.
But Your Lordship, if you would give me some latitude,
Yes.
didn't address the court the first time.
No problem.
This is my first time. My name is Joshua Mazima,
Mm.
but I think I appear to be the youngest here,
Mm.
and I have the longest time in the US. I think in both practice and age, and I think I could deliver some juvenile wisdom in the matter. Your Lordship, Madam Senior Ward, Fiona Ward, in court, what maybe is not telling you, she was nominated by the very Moses Massey, and then Moses Massey put back the nomination document. That is how she went to court. The orders that put her on the election from the High Court, to which she says would be in contempt, would be cured if the Ghana Law Society election regulations and the EC are calling for the election in the due date when she might go to become a candidate of the GS. And that is happening on the 6th of June. It is just a month away. And even in the election regulation, I think the election is supposed to happen 21 days after the notice. It gives them enough time. She will participate in the election. And now, yes, she would be eligible to participate in the election. And that would definitely take away all the legal problems on her side. Then now we can settle on the issues of the council members. the AG and the SG, as they were expelled in their first R&D number 1, there is also another case in the High Court challenging that they ought not to have been expelled. All those issues can be resolved.
But what is that case?
Your Lordship, that case hasn't been determined. It is still in the High Court. But now,
What do you want the court to do about the law of the membership, about the membership of the region of the council?
Your Lordship, I think that is best answered by the
Yeah.
respondents.
If I say that you are a woman, would you go and
I don't think you
will
will.
you bring an action for a declaration that
Exactly. But I'm drawing from your wisdom that, some people just enjoy the chaos in the US continue. But if we are all operating under the same spirit and breath, the purposes of the US, I think we can compromise on our issues here so that we can move forward. And that will be my request.
so you're saying we compromise and wait for senior counsel?
I'm simply saying to your Lordship that we compromise to bring her under the ambit of the consent, that as and when the nomination ran, because it is until the nomination day track. I don't think Paul Muchibi and Elson are scared of Fiona Wall being in the election, unless they are.
Actually, the candidates, I can tell you, the candidates were not worried about it.
Then
The candidates were not worried about having Fiona Wall on the ballot paper. The worry is the law.
and that is true. Your Lordship, had she been omitted following the law, she wouldn't be brought. But because she had been handed a nomination document which was pulled back from her, that is why she would be brought. So for us, my Lord, Your Lordship, I would think if time,
You are saying that the people who pulled away the nomination paper from her are to blame because they gave it to her.
and that is why the court in its wisdom say they have been and that's the decision of the High Court, Your Lordship. So I would think that as and when the advert runs out,
So you drive in a ditch, you can't reverse because you are fantasy official.
that is what
You drive in a ditch, you say, I can't reverse.
Your Lordship, that
Yes, I was supposed to move forward anyway, now I can't.
that is how justice plays. And I think she got her justice, and that is why she said. But nonetheless, I will not speak for
But
her.
anyway, it's compromise. It's compromise here, isn't it? It's compromise. Let's wait for.
I would think so, Your Lordship, because ideally,
No, Mr. Demcom. You are either waiting for Fiona Wall by jumping or by being pushed. Because you are actually pushing yourself. This is you guys are going to compromise. All the negative ideas come from you. So we can as well wait for 6th June, which is just more. First of all, let's see this. Under the law. You've been reading to me matters concerning the elections committee and how it calls for an election.
yes, ma'am.
But it doesn't order itself, does it? It does not. So it's independent. You see there, it's still under the law society. It's a department of the law society. It is there to conduct elections, and it cannot do so unless it is instructed by the council. How long does the council take to call for a meeting? What is the duration of the notice for a council meeting?
My Lord, that is the internal matter. We don't have, the law doesn't gives them latitude. Those are their internal matters. But maybe what I think is important, my Lord, is the.
No, I am still talking.
Yes, my Lord.
So if the elections committee was to call for an election, when do you think we will have that election?
Regulation 16,
Yes.
which provides that the elections committee shall appoint days for the nomination of candidates to elective offices, which shall be at least 21 days, and before the date of the general meeting convened for the purposes of elections.
So you have 21 days.
Yes, so there has to be 21 days notice, in other words.
21 days notice.
Yes.
And the election does not take place on the 22nd day. So don't you already have the 30 days that you need to give senior council your vote?
My Lord, well, it's something that can be obviously be discussed, but again, the justice in terms of other candidates, being fresh nominations, people pay their
No.
2 million, things like that.
There can be a compromise for candidates who have already deposited the non-refundable fee.
Yeah, but some
There can be a position. The elections committee can come up with a decision on that. Yes. Non-refundable, you have not been disqualified as a candidate, so it remains. So what is the way
My lord, it's a bit complicated. Regulation 16, actually, 16 sub clause 5.
The regulation even specifies that a person who does not pay nomination fee shall not be nominated. It's in the regulation, that's regulation 6. There are a lot of legal complications, and my lord, this is a body which has lawyers, and it's true people have disagreements about so many things. And again, law society has to value the possibility that
I have read all that, Mr. Biancama, about eligibility,
Yes,
on what, everything. We have already, all that. How do we go forward? Is the question.
my lord, to begin with, I think it's not prudent to move forward if you know what is not part of this process. We shall continue getting complaints. All the money is not present.
My Lord, I wish to
Doesn't
address the
help.
Secretary, Uganda Law Society.
Yes,
Mr. Ma, Secretary.
okay, my lord.
Mr. Ma, so it's the chairman,
Let's hear from
the Secretary.
The caretaker Uganda Law Society.
even Mr. Mar is not the acting president.
Of course, the President.
The Law Society has its president who has
Yes,
been
Mr.
really-
my
But
Lord.
I can confirm that under the law you are still secretary.
Mr. Judicial.
You are still the secretary.
My Lord,
He's the secretary, he's not suspended.
Let him talk.
my Lord, I think Regulation 13 is the one for judicials, for other positions that are outside council. The Regulation Council just put it is for law society positions. Representatives of law society, council and other representatives of law society, council like CRET and law council. But then the chairman is online, gave him the mandate to organize elections. I think he can advise on this. My junior colleague here said a very important thing. So we can wait whether, we can see whether the chairman electoral commission can advise us whether to wait or not. But still, I was personally not agreeable to having someone who is not qualified under the law to nominate, because we will create a situation where in the future I come bribe the electoral commission, they nominate me, and I use that position to represent society. Thank you.
So what is tying us down?
My lord, I think any discussion how to move forward cannot wish away senior counsel Fiona Wall and what position she has. It will simply be unattainable. We will agree to things and tomorrow she doesn't want. And then what do we do?
Has anyone ever sat with senior counsel and discussed with her this matter? I mean, the law, as it says, has anyone ever done that? That I can get a national ID which shows that I am female, yet I'm male. That doesn't change. Really?
Yes, my lord, from her submission the first time we were in court here, she seemed to want to benefit from the position that having worked for government adds up to a year, or those years can be taken as having been an advocate.
Yes, I had down that one, and I developed interest in it.
Yes. So,
But when I look at that law, it talks about practicing certificate.
yeah.
I was very ready to support her on that because she's been in government all that long. But the law was strict on practicing certificate. Maybe because you see we are lawyers, you add this law, the other one, come up with the position. Maybe if we had her, we would be of some benefit to that argument. But whereas it stands now, I have already informed you, I am going to confer with the DCG and the administrator of the court on the way forward in this matter. And I will summon you. I hope that I don't summon you after June 6th.
Yeah. Then she will be fine. So that we can get the nomination, we really won't have very good.
Actually confirms the illegality. That someone can get a confusion after some time.
But you see, you're blaming the wrong person. What did Mercy look at the time when she she walked to Mercy. They called Frank and Kalu said,
I'm not going to briefing about what's happening.
No.
what number is needed for council to
First question. No. My brother, if the law says that for you to have a court of appeal, you must be having 9 justices. Will you say that now that you only have 8, they are not 9, you have a court of appeal?
No. You see, that is the structure. What quorum is needed for a panel to sit?
That's what I'm telling you, that quorum could sit totally different from composition. But what you qualify it for. And then you say, why? But when you arrest people, like on this confusion is benefiting
No, but those are your words.
Papa.